Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and with Megan Egbert. So we are here today talking about FMLA. And Megan has recently been doing a deep dive and looking at a whole bunch of FMLA related issues. So we're going to let her take it and run today and get us kicked off on thinking about FMLA considerations that employers should be thinking about.
Yeah, I think when I first started doing a deep dive into FMLA, I thought it was going to be really boring. And I've actually been pleasantly surprised that there's really interesting stuff out there. And I'm a bit of a policy junkie, so I like to start with some of the legislative history behind FMLA to even understand how we got here in the first place. So FMLA was actually first drafted back in the 1980s. That's when they first started talking about this idea of, is there a way that we can provide paid leave, or I'm sorry, unpaid leave? At that time, they were really focused on moms who were having children. And it actually between 1984 and 1993 was introduced in Congress every single year, a different version of it. So they started with a much longer amount of time. They were asking for 26 weeks. Of course, originally there were some goals to have it be paid leave. They wanted it to apply to even smaller businesses or everybody at first. So it's gone through several iterations, and it actually passed Congress twice, once in 1991 and then again in 1992. And in both instances, President George H.W. Bush actually vetoed it. And the first time he stated that he wanted it to be voluntary for businesses, he thought it was just too big of a burden to place on them. And then the second time he talked about that our economy just couldn't handle it. So this was actually something that President Clinton really campaigned on, was this idea of leave. And it was the first major piece of legislation that he signed into law in 1993. And it's been virtually unchanged since then, except for some very small tweaks to it. And in over 30 years now, we know that it's been used 460 million times. It's the most commonly used of all federal employment laws. But still, only about 60% of the workforce is covered due to some of the FMLA requirements. So that's some of the interesting history of how we got here today.
I think and that it is pretty fascinating, really, when you think about it, and that it's largely been unchanged. But what we have seen, not in Idaho, but in lots of other states, is states then taking on different types of leave protections and medical leave, parental leave type things that go beyond what's provided in FMLA. So if you're here in Idaho, we don't really have much else. But lots of other states have kind of take it and run on their own.
Correct. Yeah. Washington has their paid leave version of it. I know other states have as well. But yeah, as a federal program, at least, it's been pretty much unchanged.
So maybe Megan, walk us through what, like, just the high level, what triggers coverage and what should, if you're a newer employer or maybe someone just getting started, what should you be thinking about whether FMLA applies or when it will if you're a growing company?
Sure. So, kind of the first threshold question is always, does it apply to the entity that you are working at? Right. And if you work in the public sector, then you're going to be covered by FMLA. And if you work in a primary or secondary school, even if it's a private one, regardless of the number of employees, you're going to be covered. And then for private employers, if they employ 50 or more employees within 75 miles of a work site for each working day for at least 20 work weeks in a calendar year, then they're going to be covered. That's a lot of math that can go into that one. But if you have 50 or more employees, then you're probably going to be covered. This includes employees who telework but might receive assignments from a location. It doesn't matter if the employees are part-time or full-time. And if ever in doubt, just would probably encourage people to count employees. It's more likely than not that they'll be considered in that 50 than that they will not be.
Yep. So if you're covered, then that would require you to give certain employees in certain circumstances as much as 12 weeks of unpaid leave off. And you talked about pregnancy and childbirth kind of being the main driver on that, but we know it's evolved into other things too. And I guess we see it in our practice with an employee's own serious medical condition.
Yeah, we see that one a lot. I think we probably don't see as much, but it can also be for a situation arising out of having a family member who's on active duty in the military, like having an emergency situation, or to care for a family member who's was injured while on active duty. Those are some of the kind of not as typical requests. And then also in addition to the birth of a child and bonding time, also the placement of a child through adoption or foster care. So those are kind of the main reasons that somebody would qualify for FMLA leave.
And we've talked before about what used to be called the Bermuda Triangle of employment law issues, right? And I don't know why it's not really called that much anymore, but what you could call it is just when employment law analysis gets really confusing because of different overlapping laws. And we know that FMLA is part of that, ADA is part of that, and workers' comp is part of that. And we do see, I think it's more common in our practice that we might see a situation where several of those are overlapping. And so someone gets sued or has a claim brought or is trying to work through that in the workplace. And I was just thinking about how one of the starting points for that I always kind of fall back on is thinking through the different policy and purposes that those acts really were intended to fulfill. And so with FMLA, it really was intended to be an avenue where employees would keep job protection, but could leave the workplace to go do whatever they needed to do. And that's an important point here. ADA is different and, really aimed at keeping employees employed in the workplace. And then workers' comp really aimed at providing really compensation to help a worker through an injury without them having to go pursue some kind of separate personal injury claim on their own. So interesting to think about what those high level purposes are. Um, so Megan, tell us a little bit more about some of the things you've been thinking through on FMLA liability and employer liability. What kind of claims and when's liability triggered with this?
Yeah, that's, I think, for me, where it got really interesting when I was doing this deep dive into FMLA is FMLA is a little bit distinct from some of those other federal employment laws that we talk about because unlike those ones, there can actually be individual liability with FMLA. So what this means is that you, not just as a benefits administrator, but even as a supervisor, could be responsible for interfering with an employee's FMLA rights and could be held liable for that interference. So this is different than like Title VII and some of our other laws, which is really interesting. And so some of the claims that we see that can come out of FMLA is an FMLA interference claim, like we were just talking about, a discrimination claim because of the way that somebody could be treated, a disability discrimination claim, and then even retaliation. And I would say that we frequently might see all of these mixed together, right? So I was reading one case when I was getting ready for this presentation where a woman had requested FMLA leave for her mental health needs, and it was denied, and it shouldn't have been denied. And then the the person that she had reported it to wasn't careful with the confidentiality of her claim and actually made some statements to coworkers about why she was gone that had to do with her mental health. So this one what started off as a FMLA request turned into a claim for FMLA interference because she was wrongfully denied. It discrimination and retaliation, all of those from this one instance. And what's interesting about FMLA interference, too, is that courts have said that it's not just denying FMLA leave that can lead to FMLA interference. If a supervisor or HR personnel, if they are making it more difficult on the employee, like they're pushing back against their requests, or they're asking them to change their appointments, or there's other things that can lead to interference and just denying it.
Yeah, and I would say that that's one of the reasons why we always encourage when we're doing our training to use a checklist. If you're disciplining someone, terminating someone, it's that FMLA interference or retaliation claim that can be pulled in if, for example, you as a supervisor or an HR person go to terminate someone for a performance issue, not really realizing that that person has put in a request for FMLA. Maybe they're gone on FMLA. Maybe they're just returning from FMLA. But that timing of having some type of FMLA request that's close in time to discipline or termination is frequently what we see lands an employer in an FMLA claim.
Yeah, interesting too with, the employee is only eligible if they've worked for the entity for at least 12 months. And it has this 1250 threshold of how many hours they have to have done, which works out to be about 24 hours a week on average. But that 12 months doesn't have to be consecutive. So you can imagine an instance too where an employee works for an organization for several years, they leave for a period of time, they come back, and they have a new supervisor who's not familiar with them. They think they're not eligible for FMLA because they don't realize their history with the organization. So there's a lot that really that supervisors need to be aware of with FMLA.
Yeah. Tell us a little bit about like when is an employer obligated to offer it, or what are some of the issues that relate to spotting an employee who needs it and offering it?
Yeah, this is one of the really tricky parts, I think, with lots of types of leave requests is that, an employee does not need to come to you and say, I need FMLA leave for the duty of an employer to be triggered. And in fact, there's some case law out there with some, wild circumstances where courts have said that an employer should have recognized that an employee needed to take FMLA leave because they were crying at work, things like that. So it can be a very low barrier, which is again why we're going to keep coming back to training supervisors, because usually employers are not going to use magic words when they come to you with a need for leave. They might just say, I have a procedure coming up, or I have to go to these appointments. There's just needs to be some indication that you need to start a process to figure out if this employee is qualified for FMLA or not.
Yeah, go ahead, Jen.
That's going to say my eyebrows went up about the crying in the office.
Yeah.
I was like, wow. I was also thinking about, ADA.
Correct.
And, I guess, you always want to be careful that you're not assuming that someone, needs something from you, but kind of thinking about it a little differently. I guess what I'm coming to in my mind is, what we always say about the ADA. You can always ask someone, how can I help you? Or do you need help? Kind of. It's, kind of the safe question. And kind of the same thing maybe for FMLA is just, how can we help? Is there something you need? And then, if they say yes, then can start the process like you were saying. is going to be the better approach to take to make sure that you at least offered the person the opportunity to, submit the paperwork and apply to use this benefit. Maybe benefit's not quite the right word, but to use this kind of leave if they need it and they qualify for it.
Yeah. Yeah. Thinking too about the uptick in mental health related issues, not only in the ADA arena, but definitely in the FMLA arena as well, and how challenging that can be for employers. Because, like you said, you just don't always know when someone has a mental health issue going on. And one more reason to be able to spot those issues.
Absolutely. I think those are the magic words that Jen was talking about is how can I help, right? And in addition to that, though, of course, you want to do the basics of you want to have a FMLA poster, posted in your work site. You want your policy to be really clearly defined in your handbook, and you want employees to get that handbook and read it so that is in the back of their mind as well. Like, oh, right, there is something if I need time off, so that maybe they're a little bit more clear when they are asking or answering what they need.
Yeah. And tell us a little bit more about the types of documentation. This is a little different than ADA. So the employer has to give the employee a notice, right? Tell us a little bit more about that.
Yeah. So within 5 business days of an employee requesting leave, and again, they might not formally be doing it in those terms, but they need to give them a notice of eligibility. And an employer can request a medical certification for an employee or for their family member if they're taking leave to take care of a family member as well. And then the employee has 15 business days usually to return that certification. And then the employer needs to communicate with them. They need to give them a designation letter. And this could spell out for them whether it was approved or denied. Um, and then it also has to include any requirements that go with that FMLA leave. Like, do they need to substitute paid leave for FMLA leave? Is there a fitness for duty requirement before they return from FMLA leave? So whatever the process is, it needs to be spelled out to them then so there's no surprises, right? What you don't want is if somebody's going to go on 6 weeks of leave to wait until 5 weeks and then tell them, oh, you have to get this certification from your provider before you can return, because that can, be a burden on them and trying to get that figured out at that time.
Yeah. And we've seen cases before where employers didn't get the medical certification, and we've seen problems with that. So we're your friendly compliance people, right? We love documentation. And if the law gives you an entitlement to get it, I would say use the tools that you're provided, because as we're going to talk about in a minute, your FMLA situation could turn into an ADA situation. Those definitely have a lot of overlap. And just the more info you have about what's going on, so you know how to maneuver through it, the better. So I would say if you've got the ability to get the certification, get it, and check the box on there that says you're going to require the return info, the fitness for duty stuff as well, because it comes in hugely handy if other stuff arises later.
Absolutely. We're going to talk a little bit more in a few minutes about some of the pitfalls of FMLA, and that is definitely, I would say, one of them. Also, I think employers don't realize that they can require a second and even a third certification if the first one seems inadequate. And also, I think we see employers all too often just accepting really vague certifications, right? I was talking to somebody the other day who said they got a certification back that just said chronic condition. Right? Like, is that enough information to go off of? And so it's okay to push back a little bit too, to say we need more information. Yeah.
I had that on my list too, because just like with the ADA, again, if you don't have a lot of tools available for you, and if getting a healthcare provider's info to provide the roadmap is one of those tools, make sure you use it. And if that means going back to the employee and saying, look, this doesn't quite give us what we need, especially if you're talking intermittent FMLA, right? We know that intermittent is one of the tougher issues that employers have to work with. And the only way you can really do it is if you have enough info from the healthcare provider to figure out what's going on so we know how to, work through that. So sending the document back with the employee saying we need a little bit more, it can be a hassle for sure, but it pays off big time if you do that and take the time to make sure you have the documentation in order. So tell us more about some of the pitfalls, Megan. What else should employers be watching out for?
Well, I think there's this idea out there that FMLA doesn't cover voluntary procedures. And I think it's just important to note that even a voluntary procedure could require an employee to stay overnight in a facility or require ongoing treatment, which both would trigger an FMLA responsibility. And so the Department of Labor actually even has some recommendations out there around voluntary procedures. Specifically, there was one instance where a woman was donating an organ to her brother. And because she was in fine medical condition, they had denied her FMLA request because she was healthy. But what they weren't, it's at the date that you are requesting the leave is when you're thinking about when the date when the leave would start is what you're actually thinking about. So obviously she would not have been healthy at the date that she's donating an organ, right? She would have required an overnight stay and ongoing treatment at that time too. So voluntary procedures, I think, are one to be aware of. Intermittent leave, which Pam was just talking about, this one's huge. And, I remember even from my time in the workplace as a manager, it was the most difficult. And sometimes with intermittent leave can come these suspicious patterns, I would say, of, an employee is able to take intermittent leave, for example, for migraines, but their migraines always seem to happen on, Fridays at 3 or Mondays at 8 a.m. And that could be an actual pattern of their migraines, right? Like who knows? But that's really important that one, you start documenting so you can see that pattern. And then that might be an example of a time when you want to request a recertification for an employee and you actually lay out that pattern to the provider and say, is this consistent with the documented reason for leave, right? Is it consistent that they would be missing on Mondays and Fridays at this time with their documented reason for leave? So I think those are a few of them. And then, ADA, we talked about. I just recently was talking to a company who ADA and FMLA are done completely separate within their organization. And I think that can be a problem if there's not cross training on it, because with FMLA, knowledge about a disability, for one, could trigger a responsibility on the employer for another type of leave too. And so with this entity I was talking to, they actually missed, I think, a request for an accommodation because the person they were talking to was their FMLA administrator. And they actually said, I don't do ADA stuff. So they did nothing with the request because of that. So I think that that's a huge challenge around FMLA, is just the way that it interacts with ADA as well.
Yeah, there's actually a case in Idaho that involved a public entity that had an employee that they terminated, and the employee brought several claims against them. And one was, look, you guys terminated me right as I had applied for FMLA. And the facts related to that were that the department and the people handling the FMLA were not part of the termination process, and the people terminating had no idea that it happened. And so that really can give rise to claims and lawsuits if you don't have the people with the info in that discipline or termination decision. One more reason you want to go through the checklist, and you got to make sure that the people who hold the info are available to weigh in.
Yeah. Another interesting one, and this actually did come up for me recently, is moonlighting. So an employee is on FMLA leave, but you hear that they're working another job. This can be a tricky one as well. I think it can depend on a few things. One, the reason why they're on FMLA leave, obviously, and the type of other job they're doing. And also if you have a moonlighting policy or not. But this is one that I do hear about. Like, we have an employee who's on intermittent FMLA leave on, Tuesdays and Thursdays. And we have a report that they're working somewhere else during that time. That's a very tricky one to navigate as well.
Yeah, good to be thinking about. I was going to go back. Me, I like to talk about the ADA. So I'm just going to turn this into an ADA discussion. One of the things I was thinking about is I feel like here we don't see a ton of FMLA litigation, but we do see a lot of ADA litigation. And we have had several lawsuits that were initiated by an employer providing someone with FMLA leave, making sure the employee got full FMLA time. And then when the employee returned to work, the employer terminated them, just not recognizing that the FMLA benefits really had nothing to do with an ADA analysis. So again, going back to that ADA, FMLA, workers' comp scheme, just because you've done everything under the ADA does not mean, under the FMLA, does not mean that you don't need to do the whole ADA process once the FMLA process is over. When Megan was talking about that migraine situation, so for example, if you had an employee who had time off under the ADA related to migraines, that would be something covered under the ADA. So then you would need to go the ADA path. And I think that trips up some employers who are maybe handling more FMLA requests with regularity, so that when they go through that, handle that, make sure that's done, it just doesn't occur to them that they've got to do a full ADA analysis too. And so we have seen several lawsuits that arose in that context.
And that's what I have written down on my little sheet here is like FMLA is not the same as like an ADA accommodation. So definitely making sure that you're running through both processes, and you might have to be doing that at the same time. It might be that FMLA comes first, followed by ADA, but it also might be that it's contemporaneous. And I'll also throw in there, potentially now you may be dealing with the Pregnant Workers Fairness Act as well, because, if somebody is taking time for having a child, they may be entitled to different accommodations relating to that. And I will say, they're kind of like Pam was talking about the Bermuda Triangle, right? FMLA does contemplate time for like bonding with the child, whereas PWFA, Pregnant Workers Fairness Act, does not. It is really focused on the pregnancy, childbirth, and medical conditions relating to that. And that certainly is a very broad set of circumstances where the PWFA can apply. But it does not apply for just, spending time with a child or child care. However, FMLA might. So, really going through and thinking through, I think I would encourage employers to really analyze any situation under each of the laws that applies, see whether or not there's anything that needs to happen, what that might be, and not to ignore any one of those laws and assume because you've complied with one that you've complied with the others.
Absolutely. And don't make people exhaust their FMLA leave before you start asking those questions either of whether this could be another type of leave, right? There's no reason for that under, what we were talking about with migraines, for example. If they're on intermittent FMLA leave, you have the notice already that they could also qualify for ADA. So if you have that information, then you should start the interactive process then.
I just got really excited there first. I was thinking, like, could you have a scenario that was like ADA, PWFA, FMLA and workers' comp? And then the workers' comp kind of threw me. I was like, maybe not. Maybe PWFA isn't going to be part of that analysis. But if you're listening to this going, PWFA, what's that? I don't even really know how that applies. Then definitely start thinking about some training, because PWFA, Pregnant Workers Fairness Act, we're seeing more and more questions on that and some EEOC movement on that. So, just an example of how things are evolving and changing, which leads us to kind of like some takeaways for you as you're thinking about what should we be doing with our FMLA house to make sure we've got everything we need. So any tips on that, Megan?
Well, I think obviously if we haven't emphasized it enough today, that supervisor training is the key here. I think that that's really important for all types of leave, but especially FMLA leave, as they might be the first line person who is hearing about a situation. I think that making sure you have a documented policy and process, Pam talked about those checklists. I can't emphasize how important those are. Being somebody who's been a manager before, if this is not your daily job, it's really hard to keep these things straight. And so I think that that's where having these checklists comes in so handy. And we have those for all different scenarios. And then, make sure that you're discussing tough FMLA scenarios with the people who are making these decisions, and involving HR often and frequently, as well as seeking legal help for some of these. The situations that we see once they get to our level oftentimes are these where now it's a FMLA interference, it's a discrimination, and it's a retaliation charge. We probably could have sorted that out in a few minutes if somebody would have sought our feedback early on in the process. So I think those are probably the most important things people could do.
I was writing down also, really understanding and knowing like your paid leave policies and attendance policies. I do think sometimes that trips people up. Like, how do we handle, kind of contemporaneously running leaves, right? Like, you can be on FMLA and you can be taking PTO at the same time, for example. And like for attendance policies, it is a tool that employers have. Like, you can still expect someone to follow like your call-in policies and kind of give, assuming they're able to, right? Give timely notice that they're not going to be in the office, things like that. So just understanding what tools are available in your policies and how they work so that you're applying them, fairly, accurately, and applying them where they should be applied.
Yeah, I was just thinking about maybe a future podcast, some of the tricky issues that we see with this. Like Jen said, that paid leave intersection, running FMLA concurrently with some other leave protections have a tendency to get employers sideways. Now we're moving from like 101 to maybe 300 level FMLA. How about communicating with employees while they're gone, when things come up? I mean, there's a lot. Clearly, this is like kind of high level. There's a lot of tricky FMLA things that can come up, but we're going to save that for another day because we don't want to keep you too long today. But we know those are, important topics too. And then just thinking about Megan's supervisor training comment, I'm always going to leave it on the supervisor training bullet point. Again, spotting the issues, it's all about that. And maybe with mental health in particular, that is one where you very well could have, I'm going to say like Bermuda Triangle with ADA, FMLA, and PWFA, because I do feel like we're getting more and more PWFA about postpartum depression type issues. So you definitely could have those three. I think we need some other term that, captures the new Bermuda Triangle that has PWFA in it. But we'll leave that. We're going to brainstorm that a little, and then we're going to roll that out in a separate podcast. But for now, that's it for today. Don't forget, we love to do training. So if you're listening to this thinking our supervisors definitely need to hear about the new Bermuda Triangle, then we're happy to come and convey that to them. Our Law for Leaders book definitely captures ADA. I was trying to think if there's a Bermuda Triangle chapter in there. I don't think there is, but you never know. We might have Law for Leaders Part 2, like churning in the background for maybe 2026 even. You never know. But check out our Law for Leaders handbook, guidebook, if you're thinking your supervisors need a starting point for basic things that they need to know on the employment law to keep them out of court. That's a resource. And as we wind up 2025 here, we are looking for our end of year wrap up that we've got in early December. Check that out. We would love to have you join us for that. And otherwise, Megan, great job. Thanks for running our podcast today. Our own Doug Class is off vacationing. So we brought Megan in to help us pinch hit this topic while Doug's out and about getting some well-deserved time off. So that's it for today. Thanks for joining us on Ground Rules, and we'll see you next time.
Thanks.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.